The idea is that we're saying that what defines a professional is now having all of those right views and the speech that goes with it, rather than somebody who has independent judgment. That you don't say, well, I disagree with that, but that's a really interesting perspective that's broadening the way that I think about this. That's what's indicating this person really is a professional, rather than someone who just ticks boxes and follows checklists.
My name is Peter Copeland, Deputy Director of the Domestic Policy Program here at the Macdonald-Laurier Institute, and I'm here in beautiful Deerhurst, Ontario for a conference on the state of political philosophy in Canada, and it is my distinct pleasure to be here with a Professor of Law at Lakehead University and Macdonald-Laurier Institute Senior Fellow Ryan Alford. Ryan, thank you for being here.
Really my pleasure.
So, let's dive right into it, Ryan. The state of Canadian political philosophy, the climate of openness to ideas on Canadian campuses and in broader society. I think we've seen the political fault lines shift in the past decades away from economic issues of capitalism versus socialism, questions of the size of government, to cultural and social issues. And we're now seeing a lot of questioning of some of these foundational ideas, such as free speech and the role and the extent, what is freedom, all of these sorts of things. So I want to ask you about free speech. We're seeing free speech issues litigated in the courts. What do we see at the judicial level regarding how these cases are being litigated? What principles are being debated? What rights are being traded off? And what are some of the tests being employed?
Well, there's been tremendous change. And it's really interesting to see how in this jurisprudence, there's a constant recognition of the importance of freedom of speech.
Okay.
But then on the other hand, you see so much more emphasis being placed on legitimate reasons for limiting speech. So in terms of the charter, you see someone successfully asserting that they have a Section 2B right. They say, this is my speech, I have a right to say it, and it shouldn't be infringed. But then the argument shifts to, yes, but we can in fact limit that right if we can demonstrate that that's reasonable. And the boundaries for what is considered reasonable are expanding quite rapidly in conjunction with this change in the zeitgeist, where speech is now seen as potentially dangerous or harmful where it wasn't previously.
Right. Okay. It's a very succinct characterization. Are there any particular cases you'd like to highlight, or like maybe a sense of the trend? I guess it's going more in this direction of curtailing, but are we seeing that shift back a little bit, or is it worsening?
From my personal experience, I see it most in the area of administrative regulation. And there was a wonderful report from MLI written by Christine Van Geyen about this. And everybody should look at it because it links into your freedom to hear. Because freedom of speech is also the freedom to hear things. So you have prominent critics within institutions. One of note is Jordan Peterson. So Jordan Peterson was censured by his college, not formally, but they said that to avoid this reprimand, you have to engage in this remedial education that teaches you that what you're doing, or more appropriately, what you're saying, right, is somehow incorrect or something that you shouldn't do because of your position as a psychologist. So we, as your regulator, are telling you to modulate your speech. Now, interestingly, this links back to what we said about the right and the limitation. In the jurisprudence, tone is part of speech. So when you see Jordan Peterson, people saying, well, he was ribald or a little bit sarcastic, or that he used epithets, that's all freedom of speech. But then they say, well, it's reasonable to limit it. And they have a very thin reed to rest it on. They say it's going to inhibit the public's confidence in the profession of psychology. Despite the fact he's not a practicing psychologist, and that really nobody would think that in expressing his political opinion, he's somehow speaking for the discipline of psychology. I don't think that's a realistic assumption. So you have the courts accepting that these regulators are inhibiting speech in the public interest to protect the public's confidence in these regulated professions. Now, who do we expect to have informed opinions about these issues, right? What's happening in psychology, what's happening in medicine, what's happening in the legal profession? It's members of those professions, right? So with respect to law, my history is that I got involved in free speech issues when the Law Society of Ontario told every lawyer in the province that they were going to have to submit what's called a statement of principles that stated their personal adherence to principles of equity, diversity, and inclusion, both professionally and in their personal lives. Which was quite remarkable. And subsequently, the courts have recognized that kind of speech in other areas to be what's called compelled speech, which is a particularly problematic infringement because it's forcing me to say something that I don't agree with.
Yeah, it's really interesting that test you referred to, public confidence, and how we see this everywhere in politics, the kind of conformity and having all of the right views as being linked to, being a virtuous person or the right person. So, it's not climate justice, but it's racial, it's all of the above, and, left and right, you see this. So that's really interesting and troubling, I think.
Just to hop in with one more point too. The idea is that we're saying that what defines a professional is now having all of those right views and the speech that goes with it, rather than somebody who has independent judgment. That you don't say, well, I disagree with that, but that's a really interesting perspective that's broadening the way that I think about this. That's what's indicating this person really is a professional, rather than someone who just ticks boxes and follows checklists.
Right, interesting. So staying on the law front for a bit, but then I want to return to universities and policy prescriptions here, government, how they respond to this. But since the charter, we've seen I think an increasing proliferation of what are known as positive rights. A negative right is a freedom from, and a positive right is a freedom to. And this is kind of undermined, I would characterize it, the sphere of negative freedom, which is this sphere to be able to choose and not be prescribed certain things. And I'm wondering, what your take is on this. Is it due to the built-in nature of the charter? Is it due to proportionality tests, to this lack of appropriate ranking of rights?
I think it's more fundamental.
Okay.
I think it's that we've forgotten what a right is. Because the whole notion of a positive right was rejected so many times, including by the Supreme Court of Canada, in the most persuasive area, which is Section 7. So you have Madam Justice Wilson writing for herself once, and you have other concurrences that have a very minority status within the jurisprudence on casting doubt on the notion of a positive right. And they're not as trenchant as they could be when they rejected. This is about 20 years ago, because they didn't need to. Because everyone understood that if you have a so-called right that requires someone else to do something, you're imposing an obligation on a private person. Right? I mean, you have right now discussions around the pro-Palestinian encampments on universities, where the argument has been made that in order for them to exercise their freedom of speech, they need to occupy private property. They need to be given the right to permanently appropriate that property to the exclusion of others as a positive measure to empower their right. And even though it's seen as an extension of a negative right, it's been slapped down because this is a step too far in the direction of positive rights. But the notion that, okay, well, you have a right to something, that empowers governments. They're now going to be the people who hand out the benefit to the people, whether that's diluted 8 milligram tablets, right, or other scarce resources of various types, or forced redistribution of existing resources, asking people if they have too many bedrooms effectively. Right. Think about how that empowers the government, which is, of course, why they see that vision of the charter as very compelling.
Right, but you're kind of suggesting, if I understand correctly, that positive rights, they're not really on the table, like nobody's really thinking that, but then yet you see oftentimes these rights being traded off in proportionality tests, right? And you're getting, I would say, effectively a positive right, or at least an undermining of this sphere of negative freedom to speak and do as you will, right? Because of the higher importance given to this other thing.
So two brief points here. The notion of a proportionality test or a balancing test is a fiction. The idea is you can have this scales of justice, and you can put something on one side and you can put something on the other. And when it comes to something like freedom of speech, you're saying, okay, this person has the right to express themselves. And then you say, but that's inconvenient to the government in various ways, right? You're there in Ottawa yelling and honking your horns and things like this. And it's really criticizing the government in ways that we don't like. How is that a balance at all? This has always been the critique. It's actually creating a hierarchy of values, right? And increasingly now, just to link it back to the theme of the conference and the panel that I spoke on, the idea of preventing the harm that comes from so-called offensive speech is always going to have a higher priority than the expressive freedom of the individual. Now, on the question of positive rights, the history of the notion of rights comes from the Universal Declaration of Human Rights after the Second World War. The history of that is fascinating because the two camps in the Cold War, namely the West and the Soviet bloc, advocated two different theories of rights. The negative right conception, which is traditional to English jurisprudence going back centuries, was a position taken by the West. And they were faced with an attempt to outflank them by the communists who said, oh, all those negative rights, they don't really get you anything. What you need is positive rights, which for the most part were group rights. So I wrote a paper recently about a critique of this by a famous French political philosopher named Raymond Aron. And Aron said, this whole notion of positive rights was just an attempt to establish what is essentially a collectivist mentality. The notion that if you don't have something, it should be provided to you by the government. And that's actually more fundamental a right than everything else, because you actually can't exercise your rights unless you have all of these positive things, something which we know to be false. But of course, which empowers the government, and then in turn gives the communist governments who are advancing that theory of rights at the time a justification and a moral superiority over the West.
Yeah, and so do you think we're seeing this, incursion on the sphere of negative freedom and negative rights from, some recent jurisprudence or, the evolution of the interpretation of the Charter over time?
I think we are, and it comes out of academia. So you have movements in thought that people think are very marginal, which you think will never escape the campus, which say essentially, well, all of these negative freedoms are really illusory. And they're manipulated by the government at best. And they say, well, for instance, the one is, there's no such thing as absolute freedom of speech, right? Because, for instance, you can't libel someone, or you can't yell fire in a crowded theater, things of this nature. But the whole point is, those exceptions were carefully cabined over hundreds of years of common law jurisprudence. The idea that just because the right isn't absolute in some cosmic sense, that it doesn't have any value, and so therefore it's unreal in a way that handing out universal basic income or safe supply drugs is real and concrete, is motivating all of this. But to see that kind of sophistry working its way into the jurisprudence is really distressing.
Okay. You've given us lots to think about here, Ryan. One final question to close, turning our attention to universities and the government and their possession by kind of ideological pressures of conformity and repression of free speech. How do you see that playing out there? What policy levers do you see are available to legislators or to people in universities to combat this, and to kind of focus on what they do best?
I think that we need to think about this very holistically and say, use the policy lever to make the university do what it's supposed to do, which is to train competent graduates. When you have graduates coming out that have received nothing but indoctrination, they actually haven't increased any of their skills, including basic literacy and numeracy, you have to say, you're not going to get the funding. All of these people who are stakeholders in the university are seen as outsiders by the university. How can you dare tell us what to do? If you want to do a Marxist adult daycare for 4 years, who are you to tell us that we can't? Well, we're paying for it. So if we have engineers being put out there, special engineers, if we're having lawyers put out there, doctors put out there, that people have to have competency with respect to not their opinions, but their competency. And that competency is declining in a way that everyone can observe. That is a clear basis for the policymakers, levels of government, to come in and say, you need to clean up your act, focus on your core competencies, demonstrate based on metrics that the graduates are capable of doing the job that you say that they're capable of doing, and then you'll get your funding.
Very good. Thank you so much, Ryan. Some diagnoses and some remedies. We always need both. So thank you so much, Professor Ryan Alford, Professor of Law at Lakehead University and a Senior Fellow at the Macdonald-Laurier Institute. Thank you for being here.
Oh, really my pleasure. Thank you so much.